thank you for having me. I ran over during the earlier session, so I'm going to try to give you all the information within 1 hour. Ask me any questions that you would like. First of all, I just would like to say, like my little catchphrase, it makes all the difference. And I think from your perspective, from legal aid, you probably know this a lot. When you have to deal with housing and employment, when all that information is not on case search and you're having to deal with it, it makes a huge difference in the criminal case. So, where's my little map? Oh, here it is. Never mind. Sorry. Okay. So I'm going to try to get started. What exactly is expungement? Just real quickly, expungement is basically, it's defined in Criminal Procedure Title 10, and it's defined basically as the removal of the criminal case from the public view. And we're going to get into details of how that happens. But we're mainly talking about police records and court records. But the first thing, I kind of broke it down into steps, because what I understand is you all are going to start working and trying to help clients with expungement. The first thing you need to know is you need to know your client's record. And the reason I put this out there is it's not as simple as just saying the client coming to you and saying, I have this case. What you really should do is kind of look at everything as much as possible. There's two sources of finding out about their criminal record. The Criminal Justice Information System, which we as criminal defense attorneys will refer to as their rap sheet. The CJIS itself is governed by statute. It's the second part of the criminal procedure article. Rules and regulation, what can be put on a rap sheet, what cannot be put on a rap sheet, what the rap sheet can disseminate, all of those things. Then the second one is mail and judiciary case search. That's the one that most people will say, that's my record. But technically, it is not their record. All it is court information. Their record is the rap sheet. The reason why you have to look at both of these, and I'm going to talk prior to October 1st, I know we're still in prior to October 1st, but I'm going to focus on October 1st. Come October 1st, having to look at their rap sheet, which for you on legal aid might be a little bit harder to obtain, is going to be a lot easier because the bars to having a case expunged, a lot of the limitations are being removed. So you can generally look at mail and judiciary case search and be pretty confident that this is the person's cases that are in front of them. However, what you need to consider when you're looking at mail and judiciary case search is you type in, I don't know, my name's Mary Denise Davis. You type in Mary Davis, I'm pretty sure there's another Mary Davis out there. That doesn't mean that all those records out there apply to me. So you have to kind of call through all that information. The other thing, perhaps the police officer wrote my name wrong. Perhaps I gave the police officer a different name. So just because the person in front of you says their name is Mary Davis, you might actually want to ask them also, did you ever aliases? Did they ever spell your name in a different way? So you can try to do different searches. The other thing about case search, it doesn't go, and here's the next screen, which I know isn't very, you can't really, I read it, but the only way that cases get put on case search when they first went, made it available to the public, was the court clerks had to download all that information from JIS, which is the official court record. They didn't go back to the beginning of time, from the first time that there was a record. So like for instance, in Baltimore City, civil cases only go back, I think it's till 98. Criminal cases only go back to 93. So if your client, and this is the other thing to consider when you have your client and knowing their record, if you have a client who's a little older, might have had a lot of cases back in the 80s, maybe even the 70s, you need to not necessarily rely on case search to get all their records. You may actually have to get their rap sheet. The other thing is, before there was a district court in Maryland, there were municipality courts, and so if their record goes back that far, you're going to have to, there's index in each of the courthouses where you can obtain that information. That's how we used to have to find court records, is you have to actually go to the courthouse, but now with case search, it's a lot of information out there. The one thing about the rap sheet, the only way the rap sheet is created is if somebody gets fingerprinted. So keep in mind, you might be like, you know what, I'm just gonna always do a rap sheet and I won't have to worry because I'll get everything. Well, you won't, because summons cases and citation cases, like traffic cases or somebody that goes to the commissioner, those type of cases aren't on your rap sheet because you haven't been fingerprinted. So neither one of them is going to capture the person's complete history, but for the purpose of expungement and the person in front of you, you got to make a judgment call, depending on their age, depending on what shows up, to just, you get a sense of what you need to do. Sometimes I'm perfectly confident, I can use case search. Sometimes I have to use both. Anyone have any questions about that? And why they have to consider both of them? Okay. So then the next thing. Yeah.
There is a cost to the
Oh yes, it does cost $38. Now, if one thing I will say, like it doesn't cost the public defender's office because it's part of the criminal case. The client has to go to CJIS, or they're all designated places around the state. They cost money. Like if you go to CJIS itself, it's $38 or $36, but these private companies, they can be up to $80 that charge to get your criminal background. So keep that in mind, but there is a cost. So, and I don't think legal aid is gonna pay for it, right? No, okay. So you might all wanna just rely on case search unless you really don't want to. Then the next thing you need to know is your case disposition. When it comes to expungement, what I like to say, I do like expungement, but it does not solve all the problems. It is not gonna take care of everything that your client wants to be taken care of. And what I mean by that, first of all, most guilty findings, 95% of them, even probably more, are not going to be eligible to be expunged. We're going to talk about the exception, because as we all remember, there's lots of exceptions to the rules, and then there's exceptions to the exceptions. But what you're really looking for when you've got the client in front of you, you're looking for the dispositions that are eligible to be expunged. Okay, does everyone know what a non-pros is? Because usually I'm talking to criminal defense attorneys, but should I go through this whole list, or do you know? Okay, so a non-pros, or no le proseque, is literally the state's attorney declined to prosecute. That's what that means. It's probably the most common favorable disposition that you will encounter. The next is stet. A stet is in the mail-in rules. The stet basically means the state's attorney, and they do have to get the judge's permission, unfortunately, can place a matter on the docket, on the stet docket. It's an indefinite postponement. Usually in the situation where the state's attorney doesn't quite want to non-pros the case, but usually because there's like a private victim, but the private victim's not there, so they kind of want this wiggle room to allow them that if the person does contact them, they can reopen the case. And the stet can be reopened during the first year for any reason by either party, and after the first year can only be reopened by the judge for good cause. And I bring that up because if you're trying to file for, a stet is one of those dispositions that has a lot of exceptions to, so just keep that in mind. We'll get to it in another part of the presentation. But a stet is a good disposition for expungement. Then a probation before judgment, your client was found guilty. There's a guilty finding, and but what happens is the judge strikes that guilty finding and imposes probation before judgment. So if you see a PBJ, it's going to be eligible to be expunged. In a couple of screens, we're going to get to the exceptions to this, but this is the general rule of those type of dispositions that are eligible. These are the things you're going to be looking for. Release without charge, that is mainly a Baltimore City issue or any other jurisdiction that has an automated booking process. What happens in that scenario is the police officer arrests someone, they take them to the facility, but the state's attorney declines. It's not quite a non-pros because there's no court case for them to non-pros. In order for it to be a non-pros, they actually have to be formally charged. With a release without charge, there's been no formal charges. Excuse me. You will only see a release without charge, and you will see these letters on the rap sheet. Obviously, it won't show up on case search because there's no case. So if your client, you're talking to your client, and your client's like, no, I got arrested, and you can't find it, you might want to, in the back of your head, remember, oh wait, could this possibly be one of these release without charges? You do not file an expungement petition, you file an application for expungement with the police department, because there's nothing to file with the courts, because there is no court record. So the applications, if you know what police department, you just go to their website. They are supposed to have the form on their website. Not guilties, I think that speaks for itself. It also will say acquittal. Then there's the dismissal. A dismissal is the difference between a dismissal and a non-pros, and you will hear this a lot from your clients. My case was dismissed. Like everything that goes in their favor is a dismissal, but it's not. A dismissal itself is an actual legal disposition, and that is when the judge from the bench dismisses the case. You don't normally see too many dismissals, and when I say that, I meant you'll usually see non-process steps a lot more than you'll see a dismissal. A juvenile transfer, I'm not talking about a juvenile in the juvenile court. That's a whole separate proceeding that you file in the juvenile courts. What I'm talking about is a juvenile that's charged as an adult. In that case, a motion is filed to transfer it back to juvenile. If that motion is granted, the adult portion is eligible to be expunged. So you can file that expungement in the adult portion. It's not going to expunge the juvenile part, but it may be eligible depending on what happens in the juvenile proceedings, but that's a separate thing. An eligible conviction, we're going to get to that, and it's smart, like, we'll get to that. And then pardons, if the governor grants a pardon and it's a crime, it's one conviction that's not a crime of violence, and the person can file for an expungement. I think I filed, in the total time I've been doing expungements, I think I did it once. That's how, it's kind of sad, but that's how many times I've actually seen a pardon that's come through my door. And then those that are no longer a crime, and this is kind of a new category under eligible dispositions. The main one that you're going to see is if you see a conviction for marijuana less than 10 grams, that is no longer a crime, and that conviction can be expunged. The other one that you will see is under the transportation article, the renting, a violation of a rental agreement. Quick example, like my mother, I'm driving the rental car, but it's really under my mother's name. That technically is a violation of the rental agreement, and I could be charged with that, but now it's no longer a crime. So under the expungement statute, that what is no longer a crime can be expunged. The other one, which I've never seen, is a defamation, criminal defamation. There's a couple other ones, but I won't go into them, but I guess the best I could tell you, if you ever see a conviction that's like, what the heck is this? And I'm not talking about prostitution or trespass or anything like that. I'm talking about like, maybe like adultery that used to be, or, something that you were like, is this really a crime? That might be something you might want to see is, in fact, it's a crime. That's the best advice I can give you. You're not going to come across that many. The one example is daytime housebreaking used to be a crime. In theory, it is still a crime. It's just classified in a different way. Whether or not the state's attorney would object if I filed an expungement for that, because the act itself is still a criminal activity. I might not win that battle, but we will try. But I just wanted to put it out there. Okay. Any questions about this one? Okay, here are your eligible convictions. And it's kind of easy to remember like what's eligible under the convictions. If you think about this as when this law was passed, if I get the term right, it was like the homeless person's expungement bill. And it was geared towards those crimes that were associated with being homeless. like not trespass, sorry. That got taken out. But is the, like loitering, sleeping on a park bench, my favorite, open container, urinating, defecating, and I'll get to the three that has the asterisk. The one about the traffic, you will come across, your client will have these MTA cases, crimes associated that occurred while they were on the MTA. All of them are eligible to be expunged unless what they were found guilty of was the exception to the exception, which has to do, like, if they're carrying some flammable material, if they have acid, something along those lines, that is an offense and it cannot be expunged. Okay. Am I being videotaped? Okay, never mind that. I won't make my comment. The three with the asterisk, that's because after the other crimes came about, another lobbying group came along, and these three, trespass, telephone misuse, and disturbing the peace, if you're found guilty, but you also get an NCR, so in criminal terms, before you can be found not criminally responsible, you actually have to be found guilty of that crime. It's a bifurcated proceeding. So if you then get the NCR on these three types of charges, you can actually get them expunged. It just, this is just me, it just irks me that, you know, the exceptions for these three, but it didn't apply to all of them. I like to see that it applies to all of them. So if my same client is found guilty of trespass, I would like to get them, their record expunged. One of the attorneys earlier in the session did bring up a good point about the whole NCR of whether or not your client is competent to even file the paperwork. I would assume that the person that's coming into your office probably does have the ability to sign off on competency, but if there is a question, I mean, it's the question with any time that your client comes in to talk to you, whether or not you really should be filing something and whether or not this person is competent. Because one of the things that they do sign at the bottom of the expungement petition is that all the information is correct and true to the best of their ability. I think that the average person, even if they might have some mental health problems, they still probably know that they got arrested, and you know, it's just basic information on the expungement petition. But she did have a point, so I just wanted to bring that to your attention. Any questions about this one? Okay. All right, so what exactly can be expunged? So I sort of told you, expungement is the removal of public records. There's two ways that you can remove something from public record. And if you ever have any questions about expungement, besides, you know, I'll give you my email, you can always call me. You can also look at the statute, because that will answer it. There's two methods. One of them is obliteration. Not many state agencies actually destroy, but some of them do. When they get that court order, they take their records and they put it right in the shredder. Most state agencies, when they get that order, what the expungement statute says is they can remove that to an area that is not accessible by the public or other employees. For instance, court cases are put in their like, I guess you could say a huge warehouse, like Raiders of the Lost Ark, and it's a huge warehouse where these files are sent, and you can't have access to them. But I will say this, after 3 years, those physical files are then shredded. So this came up in the last session, and I'll talk a little bit about it. If for any reason you ever need to reopen an expungement case, hopefully it's within 3 years, because after 3 years, you could get the court order. Like, I filed motions to reopen STED for whatever reason, but I always put in my motion and in my order to make sure that, you know, the original order is abided by and it goes back into expungement status. But you could get this judge to sign off on it and you get something, but there's nothing that's really going to be in that file, and especially if it's been shredded, there's nothing really there. And usually, well, I'm going to talk about at the end. I'm going to get to that part, but I'm going to try to get through the whole thing. And but does anybody have any questions about what expungement is? Okay. So there's two things that can be expunged. It's the court record and the police record. In the court records, think of it, I guess, the same way you would think about it in your civil cases. All that, all the information that's on case search or JIS or, everything, the index, all that, it's all going to be expunged. It has to be removed. What's not expungible is minor traffic. And one thing about minor traffic, when you're talking to a client, one quick way of knowing whether or not it's a minor traffic case, and I don't know if anybody's ever gotten a speeding ticket, but if you go into case search and it describes like speeding, exceeding the speed limit, there is a description that says fine. If there's a dollar amount, that means that you can pay that dollar amount. And what that also means, it's minor traffic. Because minor traffic means it's not impossible. You can never pay a fine to avoid an incausable traffic. You have to go to court. You have to face those charges. So in that box, the fine amount will say 0, and then you know it's impossible. Some of you might have encountered, if you work in Anne Arundel County, they've now gone to this electronic filing system that has affected a little the case search and also JIS. But it now says in that area, it will actually say must appeal, yes, no. So it kind of makes it easier. So if it's a must appeal, it's an incausable traffic. But minor traffic, when it comes to expungement, it doesn't play a role. I will tell you though that MVA will expunge minor traffic from their database. So sometimes minor traffic, like when your client says, I know I got this case, but you can't find it, it's probably been put into the historical database of the MVA, so it's no longer available on case search. Published opinions of the court, that's a big one, I think, because if you ever do file an appeal, the example I always like to use is Mr. Stoddard from Baltimore County and the reason I can tell you all this is he was arrested for going from an apartment building, going from apartment to apartment to apartment, stealing items. He got arrested. I won't go into the details, but the whole point of this is that he won his appeal, but everybody knows his case because the published opinion comes up with his name. So when you Google his name, so my advice to everyone is if you're going to appeal, do what we do in juvenile, like Mary Denise D, though they might know it's me, but you know what I'm saying. Hopefully that will help that situation. Okay, any questions about court records? It's kind of self-explanatory, but, and it's stuff, it's easy to figure out in that it's stuff that you see in the court database. Anything that you see, anything you have access to, that's what's going to be expunged. The police record, okay, keep this in mind, is law enforcement. So law enforcement is broader than just the police. It's the Attorney General, the state's attorney. That is considered law enforcement. Bottom line, police record, they have to expunge their records. They have to get rid of the fingerprints. They have to get rid of the mugshot. What's not expungible is the work product, the investigatory file. But even then, they can't just make that accessible to other people. Like they can't create their own internal database and use that in a public setting. But you will hear me say this probably a couple times throughout this presentation. I find that in some ways the expungement law is kind of clear, but the aftermath of the expungement law, like what is supposed to be used or not used after you get a case expunged, what should happen or what shouldn't happen, who has access, who doesn't have access, a lot of that is unclear, and I think part of it is there's not enough litigation, and we need more litigation. Okay, this is a big one. So first of all, you figured out what your client's record is. then you've looked at the client's record and you figured out the type of dispositions that are eligible to be expunged. You then tell your client, this is what's gonna come off. You're not gonna see it on case search. No one's gonna be able to go to the courthouse and just be able to get the information. The police have to expunge all this information. However, there's certain bars even to an eligible disposition. And I won't go into a lot of details, but that's the big thing that's gonna happen on October 1st. And one of the examples, and it's an extreme example, but let's just say your client has 50 null passes. And then they get arrested later, and they're found guilty in that one case. Under the current law, which will end on October 1st, all those prior null passes steps, the favorable dispositions, were not eligible to be expunged. But come October 1st, all null passes and all steps will be eligible to be expunged, which will make a huge difference. The one that's going to still be in place is the probation before judgment. So if you have a client that has a PBJ, you also have to look to see whether or not within 3 years of getting that PBJ, your client was charged with another crime and convicted. Because if they were convicted, the PBJ is no longer eligible to be expunged. Does that make sense? Okay. The one thing I will say, and we're going to talk more about it when we come to shielding, because that's a new provision in the law. It was referred to as the Second Chance Act of Maryland. If the subsequent conviction of the PBJ is eligible to be shielded, and you get that case shielded, then you can go back and get the PBJ expunged, if that makes sense. Then you have the pending criminal proceedings. And pending criminal proceedings, pretty much when you look at case search, if there's a possible traffic or there's a criminal case that's open or in warrant status, that is pending. The reason I put in the warrants not yet in the system, you will find if you do a lot of expungements that there's warrant cases that you did an exhaustive search and you just didn't find it. It does happen, and I won't go into details of why that happens, but just so you know, you're not going to be able to rule out all warrant cases. The other thing I will talk about with pending criminal proceedings, and this is something that legal aid has to decide, because sometimes expungements are clear. I know it's going to be granted, there's not going to be an objection by the state's attorney. With a pending criminal proceeding, two questions that can come up is whether or not a stet is a pending criminal proceeding. The state's attorney most likely, depending on the jurisdiction, will file an objection, and there will have to be a hearing, and you'll have to go to the hearing and you'll have to argue that the stet is not a pending criminal proceeding. I know some attorneys, I know some agencies will just tell the client, we're not going to file until that 1 year period. Because remember I told you with a stet, during the first year, it can be reopened for any reason. I don't agree with that in the sense, not that I don't agree with the policy of the different organizations, I don't agree that a stet is a pending criminal proceeding. I think a stet is not. I mean, it's an inactive, plain language of the statute. There's various arguments I have. If you ever want to make the argument and have the hearing, I can share with you the reasons why I say a stet's not pending. The other reason why the state may object that might throw you is if the client is still on probation for a PBJ. If they're on probation for a PBJ, it comes down to whether or not the sentence itself has been imposed or executed. Most jurisdictions don't oppose, but some jurisdictions do, and so this is another question of whether or not you want to just wait, tell the client, wait until you're off probation, and then we can file for the cases that are eligible. What else did I have? Oh, the unit rule. Like the unit rule is a big one in that when you're looking for what's eligible, you have to look at the entire case as a whole. So if one charge is not eligible, the entire thing is not eligible. And what I mean by that, let's say he has 5 charges in one case. 4 of them are not processed, 1 of them's guilty, the guilty is not an eligible conviction. You have to look, like, each traffic citation, how can I do it? You always know when you've made the cop mad when you get a lot of citations, because they have to handwrite them all out, or even on the computer, they have to do it one by one. So all of those citations that were given on the same day, and you'll know once you go through because of the sequence of the numbers and the lettering, that's considered 1 unit. Like, so you don't have to file an expungement for each of those things. You only file 1 expungement, but you have to include all the citations. But if one of them is not eligible, the entire thing, but not if it's a minor traffic. But here's the exception to the exception. If it's a PBJ for a DUI offense, driving, vehicle manslaughter, vehicle homicide, you're not going to get, that client's not going to get it expunged. When the expungement statute was originally enacted, it did not include this bar, but sometime over the course of time, a lobbying group came and said that we don't think that PBJs for DUI offenses should be eligible to be expunged. And they convinced the legislators, and now it's the law and no one's touching it. So keep that in mind with traffic cases, it's not happening. Okay, any questions about any of those things? Yes?
Just so I understand, after October 1st, with the scenario that you said where you have a conviction and all the lesser included were null props, after October 1st, you can null props those? No.
No, the unit rule has not changed.
Okay.
Yeah, the unit rule is still in place.
All right.
What changed was another provision in the law that said if you receive a subsequent conviction to a non-processed or PBJ, those 3 types of dispositions are no longer eligible to be expunged. Yes. Any questions? Okay. And then the other thing to keep in mind too is out-of-state records do apply. So when you're talking to the client, you need to say, do you have anything out of state? It's not as big anymore because usually it was the subsequent conviction that got the client, but you do need to know if you're trying to get a PBJ, whether or not they have a conviction in another state, or the other thing is they have pending cases. Yes?
You said this a bit ago, but I just wanted to clarify about the PBJ. So with the PBJ, if there is, so if there's a conviction within the 3 years, that PBJ will not be eligible to be expunged.
Yes. And then all PBJs involving like a DUI offense are not eligible.
Okay.
But I guess, I've got the exception to the exception, or exceptions, there might be 3 exceptions in this one, is I talked, and we're going to talk more about the shielding. I can't remember if I talked about this, because I might have said it earlier. Can't remember if I said it right now. But if the conviction is eligible to be shielded, according to the statute, and the statute's brand new, so it's going to be interesting just to see how it all plays out, is according to the statute, if you get the case shielded, that PBJ should be eligible to be expunged. But there is somewhat of a conflict, but we'll just have to see how it goes. But I try to take, one of the other arguments I make when I argue expungement is a rehabilitative statute, and so it needs to be construed more broadly. But yes.
So I just wanted, the clarification I wanted is that you said later that if the probation is still ongoing, so like, let's say the probation is like for 6 years or something, so is that when you were saying that that could still be counted as a pending criminal proceeding?
Yes.
Okay.
Because I don't think it is pending, but you were talking about what the state will argue.
Okay.
And so the state will argue that if you're currently on probation for a PBJ, because Robert B., that's a case, Robert B. v. State, because the state used to object that if you were on probation, even for a guilty finding, the case itself was a pending criminal proceeding. But that's one of the cases I took to the Court of Special Appeals, and yay, they agreed with me. That they said that it wasn't a pending criminal proceeding because, in fact, you've already been found guilty. It doesn't matter what happens on the violation, even if the judge sentences you, jeopardy has already attached and you've been found guilty. The difference with a PBJ is with a PBJ, when that judge struck the guilty finding, sentencing, in a sense, has been suspended. So while you're on probation, there is this possibility, if you violate, the judge may call you back into court and the judge may find you guilty. To me, that's a lot of possibilities to say that it's pending. But the state may argue that.
So even if there's no subsequent conviction, but they're still on probation, we have to have like a yellow flag.
Yeah, so the PBJ will be barred if they have a conviction within 3 years. 3 years. If you're trying to get a NARPROS, and after that NARPROS, or even before that NARPROS, that person is on probation in a PBJ case, and you file for the NARPROS, the state may object because they may say this is a pending case. Yes.
Just make sure I understand. It's 3 years from the close of the probation. Right? So if it's a 2-year probationary term, it's really 5 years after the disposition.
Well, first of all, in district court, you can only be put on probation for 3 years, and in circuit court, you can be put on probation for 5 years unless the petitioner agrees to an extension. So that's kind of the time frame that you're looking at. The reason why this is a little confusing is, and I don't blame you to be confused, I'm a little confused, because the timing to file for an expungement has to do, when it comes to a PBJ, it has to do 3 years from the date of disposition or from the date that the person has been discharged from probation, but whatever is the latter. So you have to wait at a minimum 3 years, or in circuit court, if you got probation for 5 years, you would have to wait 5 years. But the way this particular part of the statute is written, it's saying 3 years from the date of the probation before judgment.
So not the end of the probationary term, the actual time of the day you went to court and got that disposition.
That's how I'm reading it.
And then, say, you know, at like 2 years and 9 months, you get arrested, but the conviction, that case doesn't go to court for 6 months, so you get convictions, 3 years and 3 months, it has that 3-year term.
I would argue that if what you're saying is 3 years from the date of disposition, it's the when you get that conviction. So if it's 3 years and 1 day, you can get your PBJ expunged. If it's 2 years and 263 days, you can't get your PBJ expunged. If I'm right about the number of days in the year. I think you know what I'm saying. I mean, I'm not saying I'm right. This is the thing, the new laws, they're new. We're going to have to see how the courts are going to rule on all these things and these arguments. And it's also, it all depends if the state's going to object, too. Because there's no hearing if the state doesn't object, and the judge is supposed to just rubber stamp it. Okay? Yes?
How do you get out-of-state records?
You can't, in the sense of, I can't even get out-of-state records. The state's attorney can get them. Your client would have to actually go to the feds and request their federal records. But yeah, you have to, in that part, you're gonna have to rely on your client. I think you're gonna jump too many hurdles to just try to get an out-of-state record. And I think most people are pretty straightforward when you ask that question. But I also like to say, I'm signing on that everything is true and correct to the best of my ability. If they make it impossible for me to get an out-of-state record, what can I do? Other people might disagree, but that's me. Okay, any questions on this? I think I covered it all. Okay. The next step is, once you figure all that, is you should know the forms. You're going to have the petition. You're going to have the general waiver and release. You're going to have the petition of waiver of costs or the statement in support of waiver of prepaid costs by club. I have slides of them, and I have all the forms up here and other files that you're all are welcome to. the petition's pretty self-explanatory. The general waiver and release, it all has to do with filing a lawsuit. And I will say that it's the one time that I do agree that it does, maybe the police department has a point. If I filed an expungement for my client before the 3 years, and they did not give up their right to sue the police department, and then you go and file a lawsuit